and welcome to week 3 of LA 3006 Administrative Law. This week we start looking in detail at the modern application of administrative law. The first question is, what sorts of decisions can be reviewed under administrative law? In this video, we're going to break that down. We start by considering what we mean by the term decision. Of course, we know in general terms what a decision is. It's a choice, a fork in the road. However, in administrative law, we extend the definition of decision to cover 3 things. First, there are the decisions themselves. Second, there's conduct related to the making of a decision. And third, there's the failure to make a decision. Decisions themselves have their normal meaning. They might occur in response to an application. They might occur simply because a decision needs to be made. The government decision maker has options in front of them and may make a choice. Conduct related to the making of a decision is a bit more complicated. Sometimes there may be a series of steps required in order to arrive at a decision. Let's say, for instance, that someone in a government position is accused of workplace misconduct. Another person is appointed to inquire into that allegation and then report to the senior officer who makes the decision. Can you see there that the decision is going to be made by one person, but a different person's doing all the legwork? Now, there'd be no point in having a process that just looked at how the decision maker made their decision. They'd just say, I read the report and used my best judgment. Really, if you're unhappy with the outcome, you'd need to challenge the conduct of the investigation by the report writer. But there's a problem with this. No decision really stands alone. There might be 100 steps taken first. A decision whether to investigate, a decision who's going to investigate, their terms of reference, each separate step in the process, how to analyse the materials, all of these things are potentially conduct related to the making of a decision. It'd be ridiculous if every single individual step could be separately reviewed. This problem came up in the Australian Broadcasting Tribunal against Bond. The tribunal was going to refuse to renew Bond's TV broadcasting licence due to allegations of corruption. Bond didn't just challenge the final decision. He challenged a heap of decisions along the way. The court found that these little decisions, mere stepping stones, are not reviewable. To be reviewable, a decision or conduct had to be final, operative, or determinative. The court backed this up in 2 other key cases called Edelsten and the Health Insurance Commission and Kelson and Forward. You can review the conduct if it is final, operative, or determinative, and not if it's a mere stepping stone. Finally, we have the failure to make a decision. This can be as important as the decision itself. In BMF 16 and the Minister for Immigration, a permanent resident applied for citizenship, and the Minister didn't make a decision for nearly 2 years. If administrative law only allowed you to challenge decisions, then the Minister could wait 20 years, because if there wasn't a decision, there would be nothing to review. In BMF 16, the court found that government decisions cannot be subject to an unreasonable delay. For some decisions, an unreasonable delay might mean a couple of hours, whereas other decisions might be expected to take more than a year to assess. If the delay becomes unreasonable, the person waiting for a decision can have the failure reviewed. So, you can challenge a decision. You can challenge conduct related to the making of a decision, provided that conduct is final, operative, or determinative. And you can challenge the failure to make a decision within a reasonable time. Let's now think about some decisions which are not decisions for administrative law purposes. First, rule making is not reviewable. Some laws, regulations, are made by public servants, perhaps the same public servants who are making decisions in individual cases. So we ask, is the public servant making a rule which applies to everyone, or are they applying rules to an individual situation? Second, prerogative decisions are not reviewable. These occur when the decision maker has a personal power to make decisions. An example was two men named Elias and Gordon, Australian sailors in the Second World War. They were convicted of murdering another sailor and were sentenced to death. They appealed unsuccessfully. The king exercised mercy and commuted their death sentences to life imprisonment. They were actually released in 1950. The authority for prerogative powers is the Council of Civil Service Unions against the Minister for the Civil Service. The minister said that the intelligence agency employees could not belong to a union for security reasons. The union challenged this, but the court upheld the minister's decision because the court found that it was a prerogative decision, a personal decision. Finally, decisions made by national security or law enforcement agencies are not reviewable if reviewing them would compromise national security or criminal intelligence. So, what's a decision? A decision can include an actual decision, conduct related to making a decision, provided the conduct is final, operative, or determinative, and not a mere stepping stone. And a decision can include the failure to make a decision within a reasonable time. However, rulemaking is not a decision, prerogative decisions are not decisions, and decisions relying on national security or police intelligence are not reviewable decisions. The next thing to think about is that we can only review decisions of an administrative nature. We've already spoken about the separation of powers. There's legislative power, executive or administrative power, and judicial power. It makes sense that there is also legislative, administrative, and judicial decision-making. Administrative law only allows for the review of administrative decisions. So how do we tell administrative decisions from other types of decision? Let's start with legislative power, which we've already touched on. A legislative decision establishes a rule of general application, while an administrative decision applies a rule to a particular case. The boundary between the two can sometimes be really complex to identify, particularly when it looks like a new rule is being established in response to an individual case. As recently as 2016 in Jag Group against the Minister for Immigration, two judges of the Federal Court described the distinction as difficult in theory and impossible in practice. In a case called Roche Products against National Drugs and Poisons Schedule Committee, the Federal Court set out some indicators of a decision with legislative characteristics. They included general applicability, which we've discussed, public consultation in the making of a decision, consideration of public policy issues and the public interest, and a requirement that new rules be made public. However, these are indicators and not tests. Every time you consider whether a decision can be reviewed, you should consider whether it might actually be rulemaking. Judicial decision-making clearly involves a judge considering a dispute, resolving questions of fact and law, and giving judgment. When a judge does this, it's pretty clearly judicial decision-making. But sometimes public servants, executive officers, make decisions which are very similar to judicial decisions. If two parents are in dispute about the payment of child support and the child support agency makes a decision, are they acting administratively or judicially? They're certainly public servants implementing a piece of legislation, but they're also resolving questions of law and fact to determine a dispute. This can be really complicated. In Lamb and Moss, a doctor had been charged with fraud, and the case was before a magistrate for committal where the magistrate determines if the prosecution case is strong enough to go to a trial. There was a procedural challenge to the way the magistrate conducted the committal, and the full court found that the magistrate's decision was administrative in nature. This is a decision made by a magistrate in a court during a contested hearing. I would have thought it was judicial for sure, but no. In Luton and Lessels, the plaintiff challenged the decision by a judicial registrar, who's an officer of the court but not a judge. The court found that the decisions were administrative, even though they had many of the characteristics of a judicial decision. In this case, Chief Justice Gleeson said that judicial decision-making declares rights which were already in place, whereas administrative decision-making creates new rights. That's helpful. If I'm suing someone for the payment of money they already owe me, I'm just enforcing that, so it's judicial. But if I apply for a government allowance, I have no right to the money until the decision is made, so that decision creates new rights. It's an administrative decision. Second, Chief Justice Gleeson noted that a court can issue a warrant and enforce its own decisions. An administrator can't do that. For an administrative decision to be executed, they would have to seek the court's involvement. So if an administrator says that you owe a government department $5,000 and you disagree, the administrator can't just issue a warrant. They'd need to sue you. Again, though, all of these are just indicators. So when your client has a decision or conduct or failure to make a decision, you then need to ask whether the decision is of an administrative character. So you ask, is it legislative? Are they making rules of general application for the benefit of public policy? You ask, is it judicial? Are they creating new rights or enforcing existing ones? You ask, is the power prerogative or personal? If your decision survives all of these tests, you most likely do have a decision of an administrative character. So we proceed to our final test, whether the decision is made under an enactment. At the very outset of this course, we noted that administrative decision makers are not special. The only difference is that the Parliament, in a piece of legislation, has granted them a specific power, which must be used in accordance with the Parliament's rules. So for these decisions, we should be able to find the enactment under which the power was granted, the enactment which gives the power to the public servant to make the decision. In the ANU against Burns, Professor Burns was on extended sick leave. Eventually, the University Council considered whether he should be dismissed on medical grounds. In the meanwhile, Professor Burns obtained additional medical evidence. He wrote to the council asking them to consider the new evidence, but they ended his employment without doing so. Professor Burns sued the university. The question was whether this was an administrative decision made under an enactment. Initially, this seems relatively simple. The ANU was established by an Act of Parliament, the Australian National University Act 1946. This suggests that decisions made by the council, established under that Act, to run the university, established under that Act, should be decisions made under an enactment. However, the High Court disagreed. The university's power to dismiss Professor Burns came from his contract of employment, not from the legislation. The legislation gave the university the power to form employment contracts with staff, but the content of such contracts was not set out by the legislation. The decision was made under the contract, not under the legislation. So administrative decisions must be made directly under the legislation. Decisions not made directly under the legislation are not reviewable. The court developed that rule further in the Griffith University against Tang. Miss Tang was a PhD student who took the fateful, silly step of making up some of her experimental data. The university decided to terminate her candidacy. She took the university to court, claiming that the decision to terminate her candidacy was reviewable because it was a decision of an administrative nature made under an enactment. The High Court repeated the finding in the ANU against Burns that the connection had to be sufficiently direct. The court said the determination of whether a decision is made under an enactment involves two criteria. First, the decision must be expressly or impliedly required or authorised by the enactment. And secondly, the decision must itself confer, alter, or otherwise affect legal rights or obligations. And in that sense, the decision must derive from the enactment. Let's break that down. First, the decision must be expressly or impliedly required or authorised by the enactment. That means the legislation has to create the specific power that's being used to make the decision under review. So consider two hypothetical university acts. One says the university may terminate the candidature of a PhD student if they engage in academic misconduct. The second says the university may make rules regarding admission to candidacy for the degree of Doctor of Philosophy, the conduct of the candidacy, and the award of the degree. Now you can see in the first case, the decision to remove a student would be made directly under the legislation. The enactment specifically grants the university that power and sets out how it can be used. In the second case, the legislation creates a very general power and invites the university to make more detailed rules. The power is indirect. It's not expressly required or authorised by the enactment. Now, I can't pretend that this distinction is really clear, but at least we have those two guidelines: expressly or impliedly required or authorised by the enactment, and the decision has to confer, alter, or otherwise affect legal rights or obligations. There's one final thing that I need to mention very briefly. It's called the data fin principle, after a case in Great Britain. In that case, the court decided that administrative decisions could be made by private bodies if government decision-making had been outsourced to those private bodies. So if you have a private company making decisions on the government's behalf, the rules of administrative law had to be followed. That makes sense. When a decision is being made, the client doesn't really care whether the decision maker is a government entity or not. If it's public power, if it's a decision of an administrative nature made under an enactment, well, then it should follow the rules of administrative law. Unfortunately, in Australia, in a case called Neat Domestic Trading, the High Court said no. In Australia, decisions are only reviewable if they are made by a government entity. They are not reviewable if they are made by some other entity on the government's behalf. Okay, this has been a longer video than usual, but it's a super important one. To make it up to you, there's only one other video this week. See you there.